Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on an issue that whether the CPC under section 143 subsection 1 intimation can treat a corpus donation as a voluntary contribution, and the second issue before the tribunal was that if the assessee files form 10B during the appellate proceedings and the assessee could not file form 10B within the due time, so whether that is only a procedural lapse and should form 10B should have been considered by the appellate authorities. This issue has been decided by Ahmedabad ITAT SMC bench in the case of Shri Vardhaman Satanak Vasi Jain Shashwat Trust versus Income Tax Officer. This case is reported in 137 ITR Tribunal at page number 176 and the date of the judgment is 14th February 2025. The present case relates to the assessment year 2021. The assessee received the corpus donation for the building fund during the previous year relevant to the assessment year 2021, and the assessee treated this building fund as corpus and took it as exempt under section 11 subsection 1 clause D. CPC, while processing the return, pick up this figure from the income tax return of the assessee and treated this corpus donation as a voluntary contribution. The assessee filed the appeal against this intimation under section 143 subsection 1, and when the Joint Commissioner of Income Tax Appeals disposed of the appeal of the assessee, then the JCIT appeal dismissed the appeal of the assessee by saying that since the assessee has not filed the return of income in due time and since the form 10B has been filed after the due date, so the benefit of section 11 and 12 cannot be given to the assessee. The assessee filed the appeal before the tribunal, and when the tribunal heard the matter, the tribunal was of the very considered view that the CPC is not justified in treating the corpus donation as voluntary contribution through the medium of section 143 subsection 1. The moot question was that if the revenue wants to have some doubt about the nature of the donation, then the revenue should have adopted the assessment proceedings under section 143 subsection 3. But the CPC cannot treat the corpus donation as voluntary contribution through section 143 subsection 1 because it cannot be termed as mistake apparent from record. Secondly, the tribunal said that in the present case, the assessee has submitted form 10B during the appellate proceedings before the Joint Commissioner of Income Tax Appeals. So he should have considered this form, and since it is only a procedural lapse, so because of this, the exemption under section 11 and 12 cannot be denied to the assessee. Friends, this is a very welcome judgment because nowadays it has been seen that in spite of doing scrutiny under section 143 subsection 3, the revenue is making unwanted disallowances through the route of section 143 subsection 1 without going into the merit that section 143 subsection 1 disallowances can be done only for the mistake apparent from record. The complex questions like whether an amount is a corpus donation or a voluntary contribution are complex issues and they are a little bit debatable also, so they cannot be decided by straitjacket formula of section 143 subsection 1. In other number of cases, it has been seen that like the ESI PF matter, when it was a debatable issue before the checkmate decision, even the various assessees are suffering because the various additions have been done, various disallowances have been done, and after that a number of the tribunals had decided in favor of the assessee even after the checkmate decision that the ESI PF matter cannot be decided through section 143 subsection 1 before checkmate decision, and various disallowances have been deleted by various tribunals. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Shri Vardhaman Satna Vasi Jain Shravak Trust versus Income Tax Officer, and this case is reported in 137 ITR Tribunal at page number 176, and the date of the judgment is 14th February 2025. Thank you, friends.